Welcome back, everybody. I hope you're all doing well. Today we're going to be talking about corsets and patents. And the case that we're going to be talking about is Egbert v. Lippmann from 1881, the case that really sort of explains the idea of public use exception when it comes to infringement actions. And before we hop into that, here's the shameless begging that you've all come to expect of me. If you like the content, go ahead and subscribe. If you like the video in particular, give that button a little bit of a tickle. It really does help the algorithm, pushes the videos out to new people so that others in the world can listen to me pontificate and read blandly about the law, because everybody loves that and cute little pictures of Sloth in a wig. Why not, right? So let's talk about Egbert v. Lippmann. This particular case kicks off after the original patent holder, a man named Samuel Barnes, actually died, and the executrix of his estate, Francis Barnes, brought suit on what was a reissued patent for violation of that patent. This is going to be one of those times where dates actually do matter, and so the original patent was issued back on July 17th of 1866, and it was subsequently reissued on January 7th, 1873. Now, this particular patent was for something called Corset-Springs. Now, everybody knows corsets, or at least you have some picture of them in your head. Lady underpants of the bygone era that held things in and up. In effect, the springs at issue here were designed to be stronger, more flexible, and to improve the life use of a particular corset. Now, Francis Barnes was claiming that Samuel Barnes's patent had been infringed. And more particular, by the time we get here, she's saying that, and at the same time, she's saying that this set of springs had not been in public use or on sale with his consent or allowance for more than 2 years. And that part ends up being important for what we're talking about next. This is one of those times where in a civil action, it's interesting because there's no dispute that an infringement of the patent occurred. There's no debate about that in this case. Instead, the defense is actually putting forward the affirmative defense of public use. And they basically are saying that these springs, the patented item, had been in public use with Barnes's permission for more than 2 years by the time you had the original letters patent issued. And here's why that's important. The patent law at the time said that a patent would be invalid if the invention at issue were in the public use with the consent and allowance of the inventor for more than 2 years prior to the application. So in the law itself, they were saying if you rest on your rights, you waive your rights. There's something sort of similar in real property with adverse possession, but the rules are different. Francis testified that Barnes had invented this particular spring, covered by the patent issue, between January and May of 1855. Remember, he filed his first patent in 1866. A friend of their family was complaining that the steels in her corset, the thing that helped give it shape and keep it together, they kept breaking. And so he thought, I can make something better. He actually did. These springs were an improvement, but then he gave them to this friend. He made her a corset and he gave her one. And then he made her another one in 1858 and gave it to her then as well. And the thing with these particular steels, this spring, was they were so good that even when the corset, the fabric part, started fading away, you could simply rip them out and then put them into a new corset. It should also be noted, which will matter later, when he gave her the corset with these springs, it wasn't conditional. They were a gift. He didn't place any restrictions on her when he gave them to the neighbor. So the court went through 3 principles when discussing this public use and what that means and how they were going to evaluate this 2-year public use consent permission type standard. First, they said that it's not necessary that more than one of the patented article be publicly used to be public use. One all on its own is enough. Next is why I mentioned the lack of restrictions, because 2, whether it's public or private, is not dependent on the number of people to whom its use is known. Doesn't matter how many people are aware this invention is out there. If the inventor makes the device and gives it or sells it to another without restriction, such use is public even where only one person knows about it. And what ties to that is really point number 3, and that is that some inventions, by their very nature, are really only capable of being used when they aren't observable by the public eye, like corsets in this case, or jockey shorts, new dental implants, things that can't be readily seen. But if the inventor sells a machine of which his invention forms a part and allows it to be used again without restriction, that use is a public one. Likewise, where a use is necessarily open to public view, if made in good faith solely to test the qualities of the invention and purpose of the experiment, that doesn't make it public use within the meaning of this statute. Applying these 3 factors to the case at hand, the court found that for more than 2 years before the application of the original patent, there was public use of this invention that was being covered by that patent, and it was done with Barnes's consent. He gave the neighbor the springs in a corset in 1855, and then again in 1858. He did it with absolutely no restrictions recorded. And then he slept on his rights because, remember, he didn't file for a patent until 1866, 11 years later. And at that point, the corset was out, the springs were out, and they ended up coming into what the court described as general and almost universal use, which tells me that other people had started to use and copy this design, and it seems to have made it into broader use than just the neighbor. And so on review, the court found that the defendant had met the burden and established that the public use defense was proper and was applied in this case. And so Francis Barnes lost. If you're interested, the patent description from the patent is actually down in the boxes below. Give it a look. It's always interesting. But that was Egbert v. Lippmann. Let me know what you think down below. Is the public use doctrine a reasonable one? Are these 3 prongs a good way to balance the interests of an inventor and the need to incentivize creation through commercialization and public interest in gaining access to new and useful items? Let me know what you think down below, but until we are together again, I hope everybody's well.